Okay, Chapter 21, Part 2, we're talking about gender discrimination, and this slide has to do with wage discrimination, which is protected under the Equal Pay Act for male and female employees working at the same establishment doing the same work. In order to enforce this, the courts look at the primary duties of the job, that is the job content of the two jobs, and if they're the same, then the pay has to be the same. I think it's fair to say, based upon all the recent studies, that we haven't done a very good job of enforcing this because the pay for females is still considerably lower than the pay for males in the same jobs. Okay. So the Lilly Ledbetter Fair Pay Act basically was like a kind of retroactive kind of law that says that discriminatory wages are actionable regardless of when the discrimination began. Okay, what about transgender persons? Courts have traditionally held that federal law does not protect transgender persons from discrimination, but a growing number of courts are interpreting Title VII's protections against gender discrimination to apply to transsexuals. Okay, so some other topics here. Constructive discharge. If you're trying to show that you were constructively discharged and discriminated against, the plaintiff has to present objective proof of intolerable working conditions which the employer knew about but failed to correct. And the employer's resignation has to have been foreseeable. So under Title VII, you can use this to prove discrimination of any type if it is truly constructive discharge. Usually it's most common in sexual harassment cases. Okay, so probably the most common type of cause of action that ends up in a lawsuit or a threatened lawsuit is sexual harassment. Particularly nowadays with the Me Too situation, this has come even more to the forefront. So there are two types of sexual harassment that give rise to a claim for discrimination under the law. And this is court created. Okay, and they are the quid pro quo and the hostile work environment. Okay, so the quid pro quo is the easiest one. You've heard this word or this term a lot dealing with the President Trump and what occurred with regard to the trading of information on the Bidens in order to get favorable treatment, etc., etc. But anyway, quid pro quo basically means something for something. So here it's sexual favors in exchange for job benefits, whether it be opportunities, promotions, salary increases, other tangible benefits, not getting written up, whatever it might be. That's the quid pro quo. That's usually the easiest one to prove, and usually there's a trail of evidence with regard to that. The other is the hostile work environment. And here it describes what that is. It occurs when a workplace is permeated with discriminatory intimidation, ridicule, and insult so severe as to alter the conditions of the victim's employment and create an abusive working environment. So the test here is interesting. The test is whether a reasonable person would find the environment objectively hostile. So in the early days of this law, for example, back when things were worse, may not be the best word, than they are today. A typical example would be a working environment where you had an office with many people working in the office and in cubicles, and let's say men would put up centerfold pictures from Hustler magazine on the walls of their cubicle that were visible to anybody walking by. That was considered to be a hostile working environment. There's a great movie called North Country, if you want to read about it. One of the first women I believe it was in Minnesota, working in the mines, and how she was treated, and how that was a hostile work environment. And that treatment was pretty awful. I actually had a client once who worked in a retail store where her supervisor would shoot rubber bands at her breasts. That was a hostile work environment. So let's get to the test. The interesting thing about the test is it uses the term reasonable person. Well, there's an argument that's been made by feminists that it's usually women who are subject to a hostile work environment, and it's not a good test to use a reasonable person. It should be a reasonable female. And what they point to is that men generally tend to have a standard that would require a more hostile environment than what women would consider hostile. Courts have not adopted that, but it is an interesting argument and is worth thinking about, certainly. So sexual harassment by supervisors, it leads us to the area of vicarious liability we talked about before, and that is the principal's liability for the acts of their agent. And in a work environment, the business can have vicarious liability for the actions of their workers who supervise other people and sexually harass them. The law requires that the supervisor have taken a tangible employment action against the employee. Okay, the Ellerth-Faragher application is a court case. And when I was going over my notes for this lecture, I didn't like the way this was put on this slide. So I did a little research because my understanding of this rule is slightly different than what's on the screen. And I confirmed my own view in several books. So here it says the employer must have taken reasonable care to prevent and promptly correct any sexually harassing behavior, and the plaintiff employee must have unreasonably failed to take advantage of preventative or corrective opportunities to avoid harm. Okay, so what this is it's a defense that the employer can use to a valid sexual harassment claim by a supervisor in a vicarious liability situation. And generally what the law says, and this became very, very not important, but very, very useful in the last 10 years or so when this first was ruled upon by the courts. And that is that if the employer has a policy against sexual harassment and makes all the employees and supervisors aware of that policy and has a method for employees to complain about sexual harassment and a method for investigating and taking appropriate action against that behavior, then the individual employee has to first use that process before they have any cause of action to go to court. And so that's basically the defense. I think it's put a little bit differently up here, but that's what it is. And so what I meant before was that when this ruling first came down, lawyers who represented employers, were going to their clients and immediately telling them, look, this is what you need to do so that you'll have a defense if one of your supervisors sexually harasses an employee. And that's why you now see almost virtually every employer has in place this policy and this procedure for dealing with sexual harassment. Okay. Included in sexual harassment is retaliation by employers for complaints made about sexual harassment. The plaintiff must have opposed a practice prohibited by Title VII and suffered an adverse employment action in order to have a cause of action. And in some instances, the Supreme Court has ruled that Title VII's retaliation protection extends to persons associated with the plaintiff. So if somebody else reports the sexual harassment and they're retaliated against, they are also protected even though they were not the victim of the sexual harassment. With regard to co-workers as opposed to supervisors, the employer is generally liable only if the employer knew or should have known and failed to take action. Notice to a supervisor is sufficient because they're an agent and they have a fiduciary duty to put the employer principal on notice. Employers can also be liable for harassment by non-employees that the employer is aware of. So customers, etc., can be grounds for an action against the employer. Same-gender harassment in Onkale versus Sundowner Offshore Services. The Supreme Court ruled that Title VII prohibits sexual harassment extended to same-sex harassment. Proving this is a little bit difficult, but easier when the harasser is actually homosexual. Sexual orientation. Title VII doesn't prohibit discrimination based on sexual orientation, but a growing number of states have enacted statutes that prohibit discrimination by private employers in this situation. Online harassment is a new occurrence based upon social media and the like. It occurs when a hostile work environment is created using company chat, blogs, email, or other electronic means. Employers can avoid liability with prompt remedial action. It's also a reason why employers watch what you do on your computers, and we talked about that before as not being a violation of your privacy rights. And employees may be discharged for using company computers to distribute offensive material to co-workers. So if you have a cause of action under Title VII, your remedies may include reinstatement, back pay, retroactive promotions, and damages. And that ends Part 2 of Chapter 21. For this chapter, we have a magic phrase instead of word, and that is Title VII. By the way, 7 is usually in Roman numerals. All right, so we'll pick up here next video.